international level, but it's still rather an underdeveloped area of international law. So one of the things that you need is to move from rather vague general principles like the precautionary principle and use, good neighborliness and so forth to some more concrete legal norms that could be enforced at the international level. That's, in my view, largely lacking at the present, notwithstanding some stuff that does exist. Maybe you want to take it further.
So there is a precedent, by the way. I think it's sort of relevant to the question you're getting at. So there was, the name escapes me at the moment, but back in the early 1900s, there was a situation where there was a coal mining facility on the northern side of the U.S.-Canadian border.
Trail smelter.
Yeah, trail smelter case. That's it. Thank you. The trail smelter case. It was between British Columbia and Washington State, and in the northwestern U.S. And the pollution it was toxic pollution that was coming from Canada that was affecting the Columbia River, which goes all the way through the northwestern U.S. And so the question was can the United States government sue the Canadian government for failure to regulate pollution that was crossing the border? And this case has been cited. Incidentally, there's a potential lawsuit right now between the United States and China because they've detected that the air pollution that's over Los Angeles, I'm coming from Los Angeles, so I know this well, that there's scientific evidence that the air pollution that's now in Los Angeles is actually crossing the Pacific Ocean from Beijing. And they're talking about the potential for the trail smelter case being a precedent to sue the government of China. The trail smelter case was resolved ultimately through diplomatic measures. It wasn't the law. Okay, so the courts heard it, but they heard it again and again and again and again, and ultimately it ended up being a diplomatic resolution. So this is where we get to these questions as to, how far can the law go? Professor Gill just mentioned it, is that with international environmental law, so much of it is normative based and so much of it is aspirational, where you're stating principles. But as any student of international law knows, one of the things about international law is how do you enforce it? How do you make it binding? There's no overarching, to use the term of Thomas Hobbes, there is no overarching leviathan that enforces compliance. It's ultimately upon the community of the international community to go ahead and submit itself to authority. And with international environmental law, we're still working towards that. And sad to say, as an American, that the United States ultimately is one of the great failings in that regards. But until there is a community of the world that believes in international law, particularly in the question you have, international environmental law, we're going to continue to see these struggles. I think the case that you were probably having in mind is very similar to the one that was raised by the former president of Kiribati. So Kiribati, as you know, is threatening to be completely overwhelmed by the oceans within 20 to 50 years, depending on the scientific evidence you look at. And his argument was that the developed world, so the West, so the United States, Canada, Europe, they have a duty to help the people of Kiribati find a new home. And he argues that so to use the tort argument, not to say that this is a tort, but there is a harm. Okay, so the island is going to disappear. People are going to be deprived of a home, a violation of human rights. The question is causation. You can argue that there is causation in the sense that you have carbon being emitted by the first world that's causing the rising of the sea levels, that's going to cause the harm being inflicted upon the people of Kiribati. But in a court of law, that's not sufficient causation, all right? Because that's not direct causation. You have not proven that there is a polluter in the United States that is directly causing the sinking of Kiribati, right? So this is where we get to the struggles, and I think we come up with international environmental law until there's a stronger leviathan, for the lack of a better term. Ultimately, it's going to be about diplomacy.
Can you have your question, Professor Mendes?
Yes, my comment and question is directed at Dr. Jonathan in the first instance, and a second short comment to Mr. Pujaya Surya. The first one is the title of your presentation about justifying civil disobedience as a means or acceptable means of dissent. Now, this is generally accepted in democratic societies, but at the time, at this very time that we are talking, there's a serious problem that is that has reached world opinion from a little town in Missouri, Ferguson County, about the police killing of unarmed African American youth, and the manner in which the county police acted and the counter protests by the people about the inaction of the police and the reaction of the county police against these peaceful demonstrators is now world news. So what it means is that what you have said, starting from Madison in the late 18th century, a framework has been developed to try and have an instrument where civil disobedience is an accepted form of dissent. And we find currently now in the claimed most democratic of societies, total violation of their fundamental rule of law, and the American Constitution is being violated. The police are going with their badges torn off so that they can't be identified. So in that situation, where have we come after so many years of attempting to have a legal framework so that civil disobedience is an accepted form of dissent? It looks as if, in spite of all the attempts, nationally, international organizations, when it comes to real situations, in the ground, at practice, these are being violated with impunity in most of the countries that we talk about, and some of the countries that we expect a greater level of quality from their governments. That is the question that I posed to you. Mr. Vilja Surya, you made a statement about Singapore being a benevolent dictatorship. In my mind, it's a contradiction in terms.
Say it again, please.
You said that Singapore is a benevolent dictatorship. In my estimate, that's a contradiction in terms.
Right. Any other questions that anyone else? Yes, Mrs.
My question is to Professor Terry Gill. Pardon me if it's obnoxious, because it's a very radical question. I have a problem with IHL and universalism. I beg to differ that although it's a part of customary international law, now the trend is more towards restorative justice as opposed to retributive justice, as we have seen post South Africa, and as you correctly mentioned, Colombia with the case of amnesty and all that. And I also beg to differ with the Honorable Attorney General on his definition on right to development. He's my former lecturer at law school. But I think right to development also encompasses spiritual development of the person and development of the human being, that's self-development. And in my work with the war-affected people, with the child soldiers and ex-combatants and war widows, what they want is jobs, education for the children, livelihood development, skills training, that's what they want. So if you go all out to implement IHL and have war crimes and crimes against humanity investigations and forcefully bring these people to give evidence, they want bygones to be bygones and close the door and have a very Colombia, South Africa, Desmond Tutu style of, I have spoken to them personally, and they are not interested in what you said, holding the perpetrators to account, punishment. The chapter is closed. It's all done. They want to turn over a new leaf. I would like to have your comments whether this archaic law of international humanitarian law should be revisited. You yourself said that it's a very old law, and I too am guilty of double standards. I'm a lecturer in international criminal law. I recite the Geneva Conventions faithfully, and I read out provisions from the Rome Statute. But I'm wondering the relevance of IHL in today's context, and Professor Veeramantri has spoken about the cultural and religious heritage. So in a country that follows ahimsa, I'm wondering whether the IHL has relevance, and these war crime tribunals and International Criminal Court, whether it has relevance today.
Ahimsa is universal love, non-violence.
Well, there are a number of things to say to you in answer to what you've said. One of them is that, in my view, first of all, IHL isn't really either so much about restorative or retributive justice. It's about laying down a code of conduct during armed conflict. Another aspect of it is how you go about enforcing it. In fact, IHL leaves various options open. For the most serious offenses, since you're a professor of international law and teach ICL, you know that there is a regime called grave breaches, which results in the possibility, in fact, in some cases, a duty to institute prosecution. But that does not, because what you're talking about is, in fact, reestablishing a long-term peace. And for instance, as you well know, IHL has long made it possible. It's one of the things I referred to in my talk. It's referred to specifically in Additional Protocol 2 of 1977, that amnesties and other forms of restorative justice can play a useful role in reestablishing a peace, and in fact in inducing compliance with the law. One of the major problems with let's say the effectiveness of IHL in a non-international armed conflict situation is that state armed forces, of course, have the authority of the national